Precedent, the thing that came before. It's used to decide cases, it picks winners, it sometimes throws losers in jail. The claims of its authority is evoked in written words, terms from dead languages like stare decisis, or more recent inventions in the King's English, case law. Those labels are spelled out, but the real law that the concept came from is actually unwritten. Precedent is seen every day in America, but its true origins are murky, disputed even. And for most of its existence, precedent's meaning has been controversial, even forcing a president to confront a chief justice in person, in front of a crowd of thousands. So let's discover the thing that has come before. And I'll do it by simply telling you a few stories. And in one of those stories, I show the quiet warning that lets you know if precedent is being used against you. Linda Spittler was 15 years old. Her mother told her she needed her appendix removed. Linda went to the hospital. A surgeon performed an operation. Linda recovered. 2 years later, she married a man named Leo. They tried to have children. They couldn't. Linda went to the doctor. He examined her, but then he told her what had actually happened on that operating table years before. Her fallopian tubes had been cut and cauterized. She had been sterilized. Linda had never been told. No court hearing, no lawyer to represent her, no notice that anything was happening at all. A judge had signed the order the same day the request came in. Linda Sparkman sued. She sued the doctors, her mother, and she sued Harold Stump, the man who signed the order to sterilize her without her knowledge. The question made its way to the United States Supreme Court. The court ruled that the judge was immune. Linda couldn't sue him. Translation, he could take away a girl's ability to have children without process and without a law allowing it, and get away with it. The judge was protected by precedent, by the decision of a judge in a previous case. And what previous case gave Judge Stump the power to order the sterilization of a young Linda Spittler? For that answer, we have to go back to the aftermath of an assassination and the rumors of a conspiracy that supposedly caused it. Joseph Bradley was a lawyer in Washington, D.C. His client was John Surratt, one of the men accused of conspiring to assassinate Abraham Lincoln. Surratt claimed he had only planned to kidnap Lincoln, not kill him. Apparently, some of the jurors believed him. The trial ended in a hung jury. Surratt walked free. After the verdict, Bradley confronted the judge, George Fisher. He accused him of making biased and insulting comments from the bench. Fisher responded by striking Bradley's name from the roll of attorneys, ending his ability to practice law with a single order. The case reached the Supreme Court. Before Bradley versus Fisher, the rule had been that judges could be held liable if they acted maliciously or corruptly. The court eliminated that exception. Bradley versus Fisher created nearly absolute judicial immunity, not immunity grounded in the Constitution, immunity grounded entirely in a judge's decision. So a case born from the Lincoln assassination trial became the shield for a judge who authorized the secret sterilization of a 15-year-old girl. That's how precedent works. What happens when precedent is actually used to remove barriers to stop improper acts from happening in the first place? Before we answer that question, we first need to look at what law governs in America to begin with. Federal law is written down. The Constitution, the statutes passed under it, that's federal law. In 1938, the Supreme Court said it plainly in Erie Railroad versus Tompkins. There is no federal general common law. Common law exists, but at the state level. Trespass, assault, contracts, property disputes, these are areas where courts develop rules over centuries because no legislature had written them down. That's where precedent came from. England had no comprehensive legal code. Judges decided disputes. Those decisions accumulated. Later judges followed earlier ones for the sake of consistency. But even state common law sits at the bottom of a hierarchy. State statutes override it. State constitutions override those. And above everything, the supreme law of the land is the United States Constitution. The problem is this. Precedent was built for a world without written law, a system where judges were the law because there was nothing else. The Constitution isn't that world. The Bill of Rights isn't unwritten custom, waiting to be discovered case by case, yet the machinery of precedent gets applied to them anyway. And when precedent and individual rights collide, usually it's the individual left picking up the pieces. Carrie Buck was 17 when the state of Virginia committed her to the colony for epileptics and feeble-minded. She wasn't epileptic. She wasn't feeble-minded. She was pregnant. A relative of her foster family had raped her. When she became pregnant, the family had her committed. Virginia had passed a law in 1924, the Eugenical Sterilization Act. It authorized the state to surgically sterilize people in institutions, people the state deemed unfit to reproduce. The superintendent of the colony selected Carrie Buck as the test case. They brought in a eugenics expert named Harry Laughlin. He never met Carrie. He reviewed her file and asserted her being part of the shiftless, ignorant, and worthless class of antisocial whites of the South. They examined her mother, Emma, also committed, also declared feeble-minded. They examined Carrie's infant daughter, Vivian. A social worker looked at the baby and testified that there was a look about it that wasn't quite normal. 3 generations. That was the argument. Carrie was assigned a lawyer to defend her. His name was Irving Whitehead. Whitehead was a former board member of the colony. He had helped draft the sterilization law. He believed in eugenics. He was Carrie's lawyer. He barely cross-examined the state's experts. The case was designed to reach the Supreme Court, and it did. April 1927. The lawyer defending Virginia's sterilization law made his argument. He pointed to a case from 1905, Jacobson versus Massachusetts. Jacobson was a minister in Cambridge who refused to be vaccinated during a smallpox epidemic. Massachusetts fined him $5. He appealed. The Supreme Court upheld the fine. The state could require vaccination, the court ruled. That was Jacobson. A smallpox epidemic, a $5 fine, a temporary public health measure. Now, the colony's lawyer stood before the Supreme Court and argued that Jacobson meant something more. If the state could require vaccination to protect public health, then the state could require sterilization to protect the gene pool. Justice Oliver Wendell Holmes wrote the opinion. 8 justices joined him, only 1 dissented. Holmes was 86 years old, a Civil War veteran, wounded 3 times, considered one of the greatest legal minds of his generation. He looked at Jacobson, a case about a $5 fine during a smallpox epidemic, and wrote, "The principle that sustains compulsory vaccination is broad enough to cover cutting the fallopian tubes." But who decided what the principle was? Jacobson could have stood for many things. The state can act during emergencies. The state can impose small fines for noncompliance. Holmes decided it meant something else. The state could stop a person from reproducing and perform surgery to do it. Holmes continued, "It is better for all the world if instead of waiting to execute degenerate offspring for crime, or to let them starve for their imbecility, society can prevent those who are manifestly unfit from continuing their kind." Then the line that would outlive him, 3 generations of imbeciles are enough. Carrie Buck was sterilized that October. She was released from the colony a few years later. She married twice. By all accounts, she lived a normal life. She read newspapers every day, took care of elderly people in her community, sang in her church choir. Her daughter Vivian, the infant the social worker said had a look about it, made the honor roll in school before she died of an intestinal illness at age 8. But the story didn't end there. Precedent had been set. Carrie had a younger sister, Doris Buck. She was also sent to the colony. She was also sterilized, under the same law, by the same institution. But Doris wasn't told she was being sterilized. She was told she was getting her appendix removed. For 50 years, Doris didn't know what had been done to her. She married. She tried to have children. She couldn't. She never understood why. In 1980, a reporter tracked her down. Doris was in her 70s. He told her the truth. She had wanted children her whole life. The same lie, the same violation. Doris Buck in Virginia, Linda Sparkman in Indiana. 50 years apart, but the precedent connected them. But because they were treated as precedent, what happened to Carrie and Doris Buck weren't just individual cases. They were part of a movement. The man that started that movement and the impact of the Buck precedent had national impact, forever changing tens of thousands of lives. But before we get to that, I think it's important that we take a look at the past to show how precedent wasn't always there. And in fact, the system that allows precedent to even function didn't even exist for 100 years in America. The original Supreme Court had 6 justices. Each one wrote his own opinion. It was called seriatim opinions, Latin for series. If precedent were the point, that structure makes no sense. How do you extract a binding principle from 6 separate explanations? Court reporters, as an official thing, didn't even exist until 1817. Until then, they were mostly entrepreneurs looking to make money off of publishing them in newspapers and in books. It wasn't until 1874 that Congress actually appropriated funds to publish the volumes of the court's opinions. But even then, it was outsourced. Common wisdom tells us precedent was with us from the beginning, but history and the court's own organization show something else. The original place of precedent may be debated, its impact on Americans or not. This reality is clear when we examine the movement of a man whose sole mission was to stop Americans from having babies. Before Carrie Buck's case, eugenic sterilization laws existed in a legal gray zone. States had passed them, but courts kept striking them down. Doctors were afraid to operate. They'd seen colleagues sued by patients. The movement had stalled. Buck versus Bell changed everything. The Supreme Court hadn't just permitted forced sterilization, it had endorsed it. And now states had a template. Virginia's law had survived the highest court in the land. All a state had to do was copy it. And they did. 26 more states passed laws allowing involuntary sterilizations in the decade following Buck versus Bell. Forced sterilizations went from 8,500 in the 20 years before Buck versus Bell to nearly 28,000 during the 10 years after that court decision. Harry Laughlin, the expert that sent the testimony in that court case, called Carrie Buck's defeat the end of the movement's experimental period. The experiment was over. Now came implementation. Harry Laughlin wasn't just an expert in sterilization. He was the head of a movement known as eugenics. He had actually written the model Virginia law that was used to sterilize Carrie. Eugenics was a pseudoscientific movement that sought to improve the human population by encouraging reproduction among people deemed genetically fit and stopping it among those considered unfit. The American Eugenics Society hoped to sterilize millions of Americans. Laughlin's model law claimed that if enacted, the genes from the most worthless 1/10 of our present population would be eliminated within 2 generations. 1/10 of America eliminated, not through murder, through erasure, through ensuring they would have no children, no grandchildren, and no legacy. And this wasn't happening in secret. Officials spoke openly about it. A North Carolina court upholding that state's program declared that involuntary sterilization of citizens for the public good was a legitimate use of the police power of the state, further noting that the people of North Carolina have a right to prevent the procreation of children who will become a burden on the state. A right to prevent the births of people the state deemed burdensome. And when did this end? The sterilization program in North Carolina lasted until 1977. All told, as many as 70,000 Americans were forcibly sterilized during the 20th century. All of it lawful, according to the Supreme Court. But precedent didn't always rule in America. And a man named Quark proved it. Quark Walker, also known as Kwaku, which is an African name that is given to boys born on Wednesday, was a slave in Massachusetts. His first owner, James Caldwell, promised him freedom at age 25. The man who inherited Quark refused to honor the deal. Quark sued. The case eventually reached the Supreme Judicial Court of Massachusetts. Massachusetts had adopted a constitution. The first article of the Declaration of Rights said, "All men are born free and equal." Chief Justice William Cushing read those words and ruled that slavery could not exist in Massachusetts. Quark Walker was set free. By 1790, the federal census recorded no enslaved people in Massachusetts. A judge looked at a written constitution and chose freedom. Slavery had existed in Massachusetts for hundreds of years, but not all things that come before are precedent that we need to follow. You have to have a starting point. Judge Cushing chose an American Constitution, but a Supreme Court justice 70 years later would choose something else. Dred Scott was born into slavery. In 1834, his owner brought him from Missouri, a slave state, to Illinois, then to Wisconsin Territory. Both were free. Scott lived in free territory for years, married there, had children there. But then his owner brought him back to Missouri. Scott sued for his freedom. Under Missouri's own court decisions, he had a claim. The principle was called once free, always free. Missouri courts had applied it before. The case reached the United States Supreme Court in 1857. Chief Justice Roger Taney, former slave owner, wrote the opinion. Scott could not sue, Taney declared, because black Americans had no rights which the white man was bound to respect. Where did Taney find this rule? Not in what America had done since independence. Vermont had abolished slavery before the Constitution was even signed. Massachusetts had freed Quack Walker. Congress had banned slavery in the Northwest Territory the same summer as the Constitutional Convention. Not in the Constitution. The Constitution said no person shall be deprived of life, liberty, or property without due process of law. Taney pointed to precedent from England. The opinion thus entertained and acted upon in England was naturally impressed upon the colonies they founded on this side of the Atlantic. English merchants had traded in African slaves. English colonial assemblies had written slave codes. Royal governors had enforced them. This, Taney wrote, was what the founders truly believed. Justice Benjamin Curtis thought otherwise, and he dissented. He pointed to facts. Free black men had voted in 5 states when the Constitution was ratified. Black men had helped elect the very delegates who approved the Constitution. Curtis eventually resigned from the court, but Curtis's evidence would outlive Taney's opinion, and one man would make sure that would happen. March 4th, 1861. 7 states had already seceded. Armed militiamen surrounded the unfinished Capitol dome, awaiting the presidential inauguration. Lincoln stood on a wooden platform to take the oath of office. Behind him sat Roger Taney. The man who had written Dred Scott would administer the oath to the man elected to stop slavery's spread. Lincoln spoke carefully. He acknowledged that Supreme Court decisions are binding on the parties to a case. He acknowledged that such decisions deserve very high respect and consideration in parallel cases. But then, at the same time, the candid citizen must confess that if the policy of the government upon vital questions affecting the whole people is to be irrevocably fixed by decisions of the Supreme Court, in ordinary litigation between parties, the people will have ceased to be their own rulers, having practically resigned their government into the hands of that eminent tribunal. Taney sat 20 feet away. The court never overturned Dred Scott. It took a civil war and 3 constitutional amendments to do that. But for that opinion to even have come about, Taney had to reach backwards before the Constitution to precedent from England. But there was another way to think about law, another way to understand what judges were supposed to do. Long before his inauguration, Abraham Lincoln spent evenings with a geometry book, Euclid's Elements, the foundation of mathematical reasoning for 2,000 years. Lincoln wasn't a mathematician. He was a self-taught lawyer from Illinois with no formal education. But he understood something about how proof works. You start with axioms, self-evident truths that require no proof. Then you reason forward, step by step. Each conclusion follows from what came before. That's how you reach a result no honest person can deny. Lincoln saw the same structure in America. The Declaration of Independence was the axiom. We hold these truths to be self-evident, that all men are created equal. Self-evident, the same language, the same method. The Constitution was the framework built around that truth, designed to protect it, to make it operational. For Lincoln, law wasn't a collection of old cases. Law was logic, reasoning from first principles to conclusions that follow from it. In the 2012 Steven Spielberg film, Lincoln sits in the telegraph office late at night, talking to 2 young soldiers. He explains Euclid's common notion. Things which are equal to the same thing are equal to each other. Then he connects it to the amendment he's fighting for, the 13th, which ends slavery. That's how Lincoln thought. Axioms first, then reasoning, then conclusions you could prove. That scene was dramatized, but the connection between Lincoln and Euclid was not. Lincoln's law partner, William Herndon, wrote about finding Lincoln sprawled across the office floor, surrounded by papers and geometric diagrams. He described Lincoln studying Euclid's Elements by candlelight on the legal circuit, long after the other lawyers had gone to sleep. And Lincoln didn't just study Euclid privately. He spoke about him publicly. In an 1860 speech in Columbus, Ohio, Lincoln told the crowd, "There are two ways of establishing a proposition. One is by trying to demonstrate it upon reason, and the other is to show that great men in former times have thought so-and-so. Two ways. Reason it out from the framework, or defer to what important people said before." Lincoln chose the framework. Taney chose authority. When Roger Taney wrote Dred Scott, he wasn't reasoning from the Declaration or the Constitution. He was reaching backward to precedent from colonial times and English practice. He treated those as if they were first principles, as if they could override what the Constitution actually said. Lincoln refused to accept that. He refused to treat the decision as a new axiom. A case is a case. It decides the dispute in front of the court. It doesn't rewrite the Constitution. But cases are tricky. The law can be messy. How could one even notice if a precedent is being the thing used to judge the case instead of the words of the law? For that answer, we need to look a little closer at Linda Sparkman's case. The opinion that the judges wrote for that 15-year-old girl saying she could not sue because the judge was immune. So if you actually go through and read the opinion, you might actually miss something important the first go round. Look a little closer and you'll see something that makes you question. The governing principle of law is well established and is not questioned by the parties. The governing principle of law, not the law itself? So what does that mean? Well, it means precedent. It means that cases were referenced and neither party objected. But Linda Sparkman wasn't running her own case. Her lawyer was. The model rules of professional conduct say lawyers don't have to explain trial strategy in detail to their clients. Whether to challenge a precedent is often assessed by the lawyer alone. And lawyers have reasons not to fight. In 1974, legal scholar Mark Gallanter identified the problem. Repeat players, lawyers and institutions who appear in court regularly, have different incentives than one-shotters, like Linda Sparkman, who have one case and everything at stake. A repeat player can't afford to anger a judge over one client's case. There's always the next client, the next appearance, the next favor needed. So the lawyer stays silent, and court often simply calls the precedent not questioned by the parties. Words like well established and according to previous decisions usually mean the court or the other party is using another case as the axiom, and not the law itself. So does that precedent even apply to your case? If you don't object, it's unquestioned. Regardless of the precedents, there are truths that remain. The Constitution still says no person shall be deprived of life, liberty, or property without due process of law. The Declaration still says all men are created equal. Those words haven't changed. But a judge looked at a vaccination case and saw the power to sterilize. Another judge sterilized somebody else, and the nation's highest judges said he was immune. The written framework still exists. The question is whether anyone's still reasoning from it. As for me, I think I might go read up on some geometry. To learn about other quiet mechanisms that can and often do impact your life, and not always for the better, check out my Plain Meaning channel on YouTube for more episodes. And if you watch them all, don't worry, because I release a new one every Tuesday.